Hey guys, good morning. And we're here today to talk about Sarah Boone's journey through 6 attorneys. Make sure I've got everything turned on right here. Got the comments up. All right. Sorry I couldn't do this yesterday. I caught something and I'm still feeling it. So this, see, hit the wrong button. All right. I did actually read this before I started this today. So I've seen how this goes, and you will too. Most of these transitions through attorneys are just processes unrelated to Sarah, but the 2 attorneys who worked the most on her case are definitely related to her relationship with the attorneys. So let's rock this through and see what we got. The public defender was appointed for her on February 26th, 2020. So that's attorney number 1. And I think before they got actually an individual assigned, or I didn't see who it was, she gets this person right here. Padilla, Mauricio Padilla. Hang on one second here. Somebody hit the member for a month milestone. That's fantastic. Good to see that. And hello from the Gulf Coast and Texas. Always a sucker for people reporting into where they are. Now, this guy here, he was on the case for, as you'll see, basically a couple of years. And he did a lot of work on this case. Sorry, he did a lot of work on this case. I mean, lots of work. The docket is quite long, and it's mostly things this guy did. And he came on the case pro bono, and that basically means he's doing it for free. And I don't know why. I don't know if he knew somebody in the family, thought she deserved the help, thought it was good for publicity, kindness of his heart, whatever. But when he got into it, he was quite active. I will definitely say that. So anyway, he steps into the game and notices his appearance. And after that, that's when the public defender was allowed to withdraw out of the case. As you can see, the public defender came in on the 26th, but this guy came in on the 22nd. So the first lawyer that Sarah complains about, oh my God, I've had to go through 6 lawyers because she's a victim in everything. Remember, she's absolutely a victim in everything. The first lawyer was there a day before her privately retained lawyer comes in. So that lawyer, whoever it was, there's no fault there. That was somebody being assigned at public cost to defend her. And she picks up this guy who she thinks is going to do a good job for her and who was very active. So while she wants to be portrayed as a victim who's had to go through the stream of attorneys, this first cancellation you can see is clearly her own fault, but probably a good move because she's picking up somebody who's motivated to help her on the case. And the first attorney, the public defender leaving was not due to her behavior or anything. There was no time to have any conflict arise between them. So she's on attorney number 2 with this guy who, as I say, I think represented himself well, at least as far as the docket is concerned. So, all right. So then pretty quickly after that, the court grants the order allowing the public defender to withdraw out of the case. As you can see here, public defender 9th Judicial Circuit, Orange County, is withdrawn from further representation of the defendant. And good day from Long Island, New York. Hope everything is well up there. For some reason, whatever I got, it's also making my eyes a little blurry. So this is why I'm reading this more slowly than usual. But bear with me. I may misread something. All right. So her attorney, I put this in here because of what it says in it. That's when he's asking her to be declared indigent for cost. And that's so that even though he's doing it pro bono, he wants the state to be able to pay for her experts and things. And you can see in paragraph 2 here, the attorney has agreed to accept the case pro bono. So this is the Padilla guy saying, I'm doing it for free, but she's going to need help with experts and things. And you can be declared indigent for the attorney or for costs. Or the indigency thing depends to some degree on what state you're in. Somebody asked, what does it take to be declared indigent? And I didn't answer that person because it really depends on what state you're on. So I'm planning, and hopefully we'll do a video on that, to use maybe Florida and North Carolina as a couple of examples of the different ways that states determine whether you're indigent and you are entitled to counsel at state cost. All right. So anyway, that's why I left that in there. And of course she did get that. The state has been paying for her experts. In the last video we went through with her, you saw just how many experts she did have already in her case, which was surprising to me. That one I didn't read ahead of time, so it was really surprising to see just how many experts have been involved in her case. But we skipped the many pages of things that this guy did in the docket to arrive on April 18th, 2022, when he decides to withdraw. And here we have evidence of a conflict of a relationship here between the attorney and the client. And he says that here, irreconcilable differences have arisen between the undersigned and the defendant, made it impossible for him to effectively represent her. Difficult to convey the particulars to the court, at the same time maintain all duties to the client. And that's one of the things about withdrawing. You can't just blast out there, my client's a guilty butthole and, wants to lie and think, not that I'm saying he would say that about her, but the point is you still got professional responsibility towards your client. So it can be dicey at what you say when you want to withdraw, and the court respects that, typically speaking. On the other hand, the judge, if they can, they like to keep people in the case, so they may ask you questions about it and try and ferret out whether this is something the judge maybe could help clear up or something like that. That did happen later in this case. It didn't end up happening here, but you'll see from the record, Sarah steps in to give her point of view to the judge. And now you see how her behavior is. Here's a guy who, from what I know at least, worked on her case for a couple of years, doing a lot of work, a lot of experts, but also a lot of work that we haven't covered. Maybe somebody else has, but the docket has pages of things that this guy did, lots of activity. And she's writing to the judge, thanking him for his invaluable time and concern. And it's unexpected and incredibly confusing matter in regards to the requested withdrawal. My team, forgive me the wrong approach. She wants the judge to know the magnitude. This is back when she used to write the judge and not everybody. Magnitude of her shock and disappointment in the betrayal of the attorney, as she has not in any way by anyone been provided any explanation for the aforementioned withdrawal. She learned of these documents from her former husband. After making a commitment to me as my attorney for over 2 years and 2 months and making me believe her team, I'm completely blindsided. Does anybody believe that? I don't know that I believe that. I don't know that I believe that she's blindsided there. And she wants to be present at the hearing. Because, she could have essentially written this letter, and she has, regarding the attorney she currently has and some complaints about him. So I'm reminded of that saying, the common link in all your failed relationships is you, Sarah. And maybe you ought to think about that. Let's see. All right. I'm also looking to make sure I'm not missing any comments that we need to pump up here. So she wants to fight for my truth. So she was on that note last year. I thought my attorney was doing this also. So, she's betrayed. She just wants to move forward. Entire predicament, et cetera, et cetera. So I don't know what she thought was going to happen by blasting her attorney like this, but ultimately it didn't work out. The attorney filed an amended motion to withdraw, which is a little unusual, but I think you'll see probably why that occurred as we look at it. The undersigned is forced to withdraw as differences have arisen between them that made it impossible for him to represent his client. It's difficult to convey the particulars. And then there's a little bit of added information here. The relationship has become adversarial. That's easy to believe. The aforementioned relationship has interfered with counsel's ability to effectively represent his client, especially preparing for trial. And you'd just be using your imagination to think of what that could be, but obviously there could be a conflict, and she thinks he should be doing more than he's doing. She thinks he should be getting different results from the efforts that he is doing, or she thinks that he should be doing different types of tactics and strategies than he's willing to do. Those are, the things that normally you would see come up with that, or spend way more time on this than you're already spending on it. Sometimes people think you're the only client that they have. And my experience is when something's free, people tend to value it that way. And I could see that occurring here, to where she might have thought his time was worth what she was paying for it. Anyway, the undersigned appreciates the court providing him the opportunity to amend his previously filed motion to withdraw. After further researching the issue, he's still under the belief that the specifics of the adversarial relationship may disclose information that could prejudice his client, and so he will stand mute on the specifics. But he's making this motion in good faith, and so that's enough for the court, apparently. I think the court said, look, you got to give me a little bit more in this. We want to get this case to trial. What's going on here? Is this really something where you have to leave? That was the attorney's response. Yes. I'm going to put this up here. Exactly right. So one thing she's not good at is introspection, and she doesn't spend her commissary money on any kind of mirror. So then we have, she's declared indigent, appoints the public defender. And that's when we get some action going again. So you see here the public defender's office is appointed again, and he's going to let Padilla off the case. But let's look at the timing of this, because this is pretty quick. What is the date here? May 10th. And then, well, this was a little later than I thought. June 6th, certification of conflict and motion to withdraw. So Robert Wesley, who's the third attorney on the case, says, I got to get out of this case. And that is, I believe, because, yes, the public defender's office represented the decedent in this case, Torres, in a domestic violence case where the defendant was the victim. It'd be a conflict of interest, he says, because the defendant's interest and those of Torres were adverse, hostile, and irreconcilable. And that's a former client or whatever and all that. So he says, we got to get out. You got to let us out. It would violate all of her rights if we were to try to be her lawyer after this situation has arisen. And then the court says, yep, I'm going to agree with that and let you off of this case. Yeah. How happy will the ex be? He seemed to be, to me, kind of guy who's still trying to support her all he can. And it wouldn't surprise me if he was paying the rent from this comment saying, how can you imagine how happy her ex will be when this is over? I think he was paying rent. That wouldn't surprise me if he was. And it would kind of surprise me if he wasn't. Her civil background, it does involve some foreclosures and things like that, some financial problems. And of course, he, I think, was the guy who got called when she woke up that morning and was in the situation she was in, having caused the death of her partner. Anyway, so the court says, all right, so we're going to let the public defender out. So the public defender's office got out the first time very quickly because she had a privately retained attorney, but now they're back. And the Office of Criminal Conflict and Civil Regional Counsel, TBA, is hereby appointed. So your attorney is TBA. This is the 7th day of June. And here comes this attorney, David. I don't know how to pronounce his last name, but let's say it's Verrett. He steps into the game on the 10th of June, and he is attorney 4. And then the 10th of June, he's like, I got to get out of this case, Judge. Here comes the assistant regional counsel and moves the court to enter its order allowing him to withdraw from the case because they previously represented the witness, Melissa Sexton, in multiple cases. So now we've got 2 lawyers getting out of the case for conflicts really regarding other people they've represented and not doing anything on this case. They're not having a chance to develop a good or bad relationship with Sarah because they're pulling out of the case. Let's see. He claimed he was in an interview with the detectives. I think that's talking about the paying of the rent. He wasn't complimentary to her at all. Sounded like she was a nightmare to deal with. I'm sure all of that is true about the nightmare part. And I think, it strikes me that he's a guy, though, when she called, he would nevertheless try and help her. And she probably rode him like she's trying to ride all these other people, taking advantage of him as much as she could. And they have a son together. So, if he was helping her, that might explain some of why he was doing it. Let's see. Another local lawyer here on the live stream. And, thanks for coming by. And if I'm leaving this up for a minute, if anybody hasn't checked this channel out, you really should, because there's some fine legal analysis on her channel, multi-state and deep into cases. It's fantastic. So a true gem and inspiration to lawyers who like to do this kind of thing. Oops, why did it go away? I just put this up here. All right. So the assistant regional counsel wants to bag out due to representing somebody in the case. More victimhood for Sarah. And the court says, yep, that's fine. You can get out of here. We'll see you later. And then the court appoints Mark Consalo. So I don't know who that is. That's probably just a local lawyer that agrees to be appointed when when they need people to be appointed because he's not part of the public defender's office, probably. In the interview, the ex-husband claimed that neither she nor Jorge had jobs. And yeah, likely true. So this guy steps into the game. Poor guy. Let's see. He's not here long, according to my notes. So he appears in the case, and pretty quickly he's going to disappear from the case. On July 8th, he wants to withdraw the conflict in representation that precludes him from further representation in the case, and it's no more specific than that. You'd think as big a county as that is, you'd find somebody who didn't have a conflict. But in her case, if I were a public, defending type person and I could come up with a conflict, I might really try to do that. I could think of a lot of types of people that I'd rather represent than her. And the court says, yep, I'm going to let you out of here. And here comes Frank Bankowitz into the case. And that was on July 11th when this was filed. And he's the current attorney. However, of course, he has tried to get out of the case. And he filed a motion to withdraw in December of last year, which this was a slightly different than other motions you've seen, an odd addition. There's a conflict between the undersigned, his client, and his family, causing him to be unable to effectively and properly continue representing the defendant herein. I don't really know what all of that means. And maybe that's his way of signaling to the judge something there more substantial than some of these other ones. I don't know what that is, but that's unusual to put that in there, something about your family, whether it's a conflict you got with your own family or somehow a conflict she's got with your family. I don't know that. So that's bizarre. But the court did say, here we are right here, that when they heard this, the defendant did not ask the court to remove the attorney. So she doesn't like this guy, she says, according to her letters, and he should be doing more, just like all the other lawyers should have been doing more. But she did not ask the court to remove him, and the court denied the motion to withdraw without prejudice, and that means he can bring the motion again if he feels that he should. And he said, coordinate a meeting with this defendant prior to the pretrial conference. I think that those things did happen. So she still has this attorney because she did not ask the court to remove him, and I guess the guy agreed to stay on, and the court probably said, if you can, carry on, because we got to get this thing to trial at some point before a meteor hits the earth and destroys everything. And so here we are with that. So six attorneys so far. And the stream looks fine from here. It's hard for me because I can barely see it myself, but I'm sweating, believe it or not, from whatever it is I've caught. Bizarre. Anyway, so that's 6 attorneys on this case so far. Not she hasn't made it to lucky number 7 yet. And as I say, when you read her complaints to the judge, you have to, even though she's fairly vile and she's obviously self-centered and all those things, you still have to look at it and go, if you're the judge, is she reporting something to me that is a violation of her rights or something I should address? Or is she just continuing to spew up victim status stuff to me? Because the complaints she's had about the new attorney are similar to the complaints she had about the original pro bono attorney. And that guy worked the heck out of this file. You can look at the docket yourself and you'll see all of that. So I don't know what the truth is. And, has the attorney talked to her enough or not enough? It's obvious that she probably thinks that she's entitled to a lot more time than she's getting. She's also probably thinks she's entitled to a lot more time than she deserves, or maybe even that her case needs, because a lot of work has already been done with the case. I mean, how many more things can you learn about this? And it happened in one night. Yeah, I was in the suitcase. He died. She didn't let him out. She videotaped it. She's going to try and claim she was scared of him. They've had numerous experts look at all this. This isn't a mystery. This isn't John Bonet. Okay. Everybody knows exactly what happened. And everybody knows that she wants to say that she was scared so that she can go battered spouse. And that's stupid, but that's the whole plan. I mean, this isn't a mysterious case. So that's what I know about that. So let's see. Anybody got any more comments on this? Because believe it or not, we actually got to the bottom of this. I'm still sentient to the degree that I can be. So to recap it anyway, this current attorney, the one that she constantly complains about, he has asked the court to appoint another expert in the case, forensic psychologist, even though, as we looked at last time, there have been 1, 2 of those at least appointed in the case already, plus some domestic violence person, plus this, plus that, crime scene people, cell phone people, all of that stuff. They've all been appointed and worked on the case and spent a lot of money already. He wants another one for $400 an hour. And I suppose that would go toward this battered spouse thing. And the state is objecting to paying that level of cost, the agency. So it's calendared for September, and then the trial calendar for October, but defense and the judge agreed that the October thing is really just administrative, that it will pass on beyond that. So, likely that this case goes into next year, I would think. Anyway, I'd be surprised if it happens before that. And it's frustrating that this trashy person is costing taxpayers tons of dollars, wasting judicial resources. Yeah, I agree with that. And of course, some people will say, well, why doesn't she just take a plea bargain? Well, I don't know that the state has offered her that. She's got enough time in. If they were to go manslaughter, she'd be kind of dumb not to take it, because I think her defense against second-degree murder is pretty poor. It really would rely on people thinking that she did what she did because she was a battered partner, and I don't think that will sell. I really don't. So, and then maybe to go on top of that comment, she should represent herself. I just don't think she's the kind of person who would do that, though. She seems to be much more the caring kind of thing, where she's completely able to tell you, the judge, the planet, her attorneys, the doctors, how they should do their jobs, but not really so interested in actually doing those jobs. She's more of a consultant kind of a Karen, that she wants to let you know how you're doing it wrong, but I don't think she will step up to the plate and attempt to do it herself. She could, but I don't think that she will. I'd love it if she represented herself. That would be quite interesting. It really would. And I think she might, to some degree, she might even be strangely dumber than Daryl Brooks in that she would be constantly complaining about actually being the victim here, where at least Brooks was just largely talking about stupid things like a flag fringe and stuff like that. So, whereas I think she would make you feel on a every time she spoke basis just how self-centered somebody can possibly be. And I don't think she would take a plea deal until maybe it was for time served. Well, that's kind of what I'm saying. So if you get into a manslaughter situation, at some point you're building up a bank of time that you've already put in. You got to look at that, what you're gambling going to trial on second-degree murder for your potential sentence there. If she stays in jail long enough, she can have time served. If the case keeps getting delayed, it's something she's certainly happy to remind people about, is how long she's having to spend in jail. And there's something going on here, I think, with this first pro bono guy who worked the case so hard, and then saying, as it appeared he was developing the case towards trial, that he couldn't get to trial without the relationship breaking down to the point that he couldn't effectively represent her. And she missed the boat there, because that guy was pretty close to taking the case to trial. What happened there? I mean, the attorney had done a lot of work. Something, as I said, happened there. Either she wanted something done that he wasn't willing to do. She was constantly complaining about all his efforts and blaming him and things like that. I don't know, but he did a lot of work just to pull out of the case without seeing it to the end. And then she's making similar comments about this new attorney. So there are sketchy online law degree programs. I didn't even know that they had that. I got my JD long enough ago that there weren't so many law schools around back then, and the flaky ones, people pretty much knew the names of those. But these days, I think there probably are a lot of that. There were a lot of law schools that started up that really had no business starting up, and mainly served to absorb the money from people in the form of student loans and things, I think. Not that I don't think it should be an exclusive club necessarily, but I do think, given what you're doing, which is being an advocate for people in situations where their freedom or their livelihood can depend on it, that there's a level of competence that should be there, and not everybody possesses it. Of course, accompanying this lowering of the standard of getting a JD was, well, should we even have a bar exam? That's terrible. Okay, yeah. Can a lawyer represent a client without really communicating with the client? Well, I think that would be hard to do, right? There could be an extreme case where that could make sense. Sometimes it does occur. I mean, what if you have somebody that's in a coma or something like that and you're appointed or whatever? That's pretty extreme, but I don't think that it is the case that these attorneys have not communicated with her. Now, I do know that she's made some pretty specific complaints about the new attorney, the phone number and all that stuff. But what we haven't seen is his side of the story, and that he shouldn't be doing that. He shouldn't be responding to her letters and saying, but this, but this, but this. He can answer some things like that if the judge asks him. That is not his job, is to litigate differences with the client in public. So what you have is somebody who thought it was hilarious to leave somebody in a suitcase until they died, and then blast her first lawyer who worked for free for years as some kind of traitor to her cause, making the current complaints against the new attorney, which some of them do superficially sound like, is he doing all he should do? But you don't have the other guy's point of view on this. So I don't know the answer to that. That's why I say, I'm not out to judge the new lawyer on this case, because the person who's making the complaints is an unreliable narrator, to put it mildly. I think she doesn't want to go to court. Well, that's interesting. I hear that. I kind of disagree with it in that I think she does want to go to court, but she wants it to be Burger King court, where it's all going to be her way, that these experts will get up and talk about the valor that she has and how horrible it's been for her, and the system has been out to get her, and she's a total victim, and that everything should go her way, and there shouldn't be any risk or anything like that. So I think she would like to have her imaginary court proceed and not the real one. And I always come back to the Burger King court, because the one time when I withdrew out of a case, the judge didn't let me do it at first. And it's a civil case. You can imagine some of the reasons why I would have wanted to withdraw when you're not on a contingency fee. But at any rate, the judge said, well, do this. You do this, client, you do this, lawyer. And if either one of you don't do that, we'll come back together. And certain things didn't occur, and we came back together, and I was allowed to withdraw out of the case. And the judge informed the client, who then said, I think we'll just do it ourselves, that this will not be Burger King and you will not have it your way, which I think is a strong advice to everybody. It probably should be on their website. There are just certain things you need to know if you're going to go to serious superior court stuff for civil litigation. Like I don't cross streams, like I don't go do domestic cases, or didn't. I'm not really doing too many cases now for some certain reasons, but because I want to do something else soon. But at any rate, I wouldn't go do domestic cases, not only because I didn't, that wasn't the thing I wanted to do, but if I'm focused on commercial litigation and I go take a domestic case involving child custody and things like that, do I even know those judges? Do I know what sells in that courtroom and what doesn't? Do I know the nuances of the law? And likewise, when I was doing superior court kind of commercial litigation, if a divorce lawyer represented somebody in a case and then had a good relationship with them and then stepped over into commercial litigation because that's the lawyer they knew, you could often hand them their butt in superior court because they just didn't know how that court functioned. They're different things are different. Federal court is different than state court. Family court's one kind of law. Criminal law is a different kind of law. Civil. I'm rambling to some degree. I'm putting that down to the fever. So anyway, I think we've gotten this topic ironed out. So most of these lawyers, you can see, were not, there weren't 6 lawyers that she got into fights with. There were really 2. And the first one left. The second one that she got into a fight with is the current one. He didn't leave. They worked it out for now, even though she continues to send letters. All the other lawyer transitions were technical in nature, basically related to professional conflicts. Now if you just read her letters, you would think that she was abandoned by 6 lawyers who maliciously refused to work on her case. And that is not the state of the file at all. What the state of the file is that the 2 lawyers who did work on the case apparently developed conflicts with her. And those being 2 different people, again, you have to start thinking maybe you should work with your lawyer a little differently if that's part of the problem. When they showed that video of her laughing at him while he's in the suitcase, not letting him out, even though he's begging her, yeah, she's done. I think that's true. A legal focus says, oops, I do have one superior court case, but mostly I do family law these days, no federal court cases. Yeah, well, I mean, you know what I'm saying. I did have one where there was a family lawyer who came from Charlotte, which used to be a bigger deal than it is probably these days, up to where I was. And I wasn't exactly prepared for the kind of motions practice that we did in Superior Court here. But it all depends. If you know the subject matter in the case, of course, you can do it. And it's not like I've never done a domestic case, in that I have begrudgingly helped people through some things like that, and even done some divorce stuff. As long as there are no fights and custody things, I will not help people fight over kids and things like that. It's not my thing. So it doesn't always work out poorly for people to move from one section to the other. But as long as you're humble enough to respect the fact that if you walk into new terrain, you need to understand there are things you don't know, then you can adapt to that. That's one of the things about pro se people. You see them sometimes go into court like they think they already know everything. They're not going to listen to the judge. They're not going to listen to the other side because they know everything. They already know everything. So if you have some humility to understand that, if you're stepping in front of a judge you've never been in before, a courtroom you've never been before, you need to watch what's up. And I remember going to Asheville for court when I was well east of there. And, they all know each other. They all know each other. And so you're in their courtroom there. So you need to present yourself accordingly and that sort of thing. It's definitely odd when someone gets an attorney from a faraway county or even out of state. People are usually better off with a local attorney who knows rules. And a courthouse folks, again, that's from A Legal Focus. Yeah, and that's just, that's the old saying, a good lawyer knows the law and a great lawyer knows the judge. Because how the system gets applied is part of knowing what's going on. And, what judges think, I would do a motion to dismiss, or I'll never do it because I could get reversed. How to schedule things and get it in when you want. How to get the judge who might be most favorable to the positions that you want to apply. All of those things. Local knowledge, local terrain. I mean, one of the things I did in the Army, which did help me understand this for law before, was what was taught to us about how much to study, where we were going to go before we ever got there, and how to prepare the battlefield, and how to learn all these things and know as much as you can before you ever get there. So you're surprised less. And that is the same in court. You want to know what you're walking into, and you'll see some attorneys are very comfortable in court, and they can be especially comfortable if they've been in those courtrooms before and they know all the people involved. And then, I did say yes. I went to Bladen County Court and said never again, stepping back to 1950. So yeah, a little bit of street knowledge on that is one time I was talking to this lawyer in the office I was working in, and he was countering a motion to dismiss, a 12B6 motion that the defense had made. And I'm like, yeah, but you're the plaintiff in the case. That's his motion. And he goes, that doesn't matter. He put it in his answer, so anybody can calendar it. And I was like, what's up? So if you want to drag somebody in for hearing, because everybody puts a 12B, or they did put a 12B6 in their answer, and then you could schedule that and go in front of a very confused judge who's like, what's up? And go ahead and get that litigated. That's an interesting way to cause a hearing and get it out of the way. Of course, it's totally legitimate. The current attorney actually has a good reputation in Central Florida. He's currently the defense attorney in a death penalty case. Yeah, and so I have nothing to say on him one way or the other on it. Like I say, some of her stuff superficially sounds like, is this guy spending the amount of time he needs to on the case and available for her in a reasonable way? But the point is, while she makes those claims, you only have her word for it. And she's fairly unreliable. And she has been in front of the judge on this very issue. So she says she wants to go to court, but yet she wants another expert, and that's fine. And we'll see if the judge doesn't give her this new expert. They've already had experts, and they need to just use the ones they got. And if it worked for the defense she wants to present, fine. If it didn't, she's going to have to live with that and eventually get this case over with. And then she can start her real sentence. Yeah, street lawyer. I mean, yeah. You should know a little bit about that, especially as a legal focus says. Yeah, now see, I have the benefit there because I'm from a very rural situation, being from way out in the country in Virginia, that I could walk into any of these courtrooms and it looks like I probably ought to be there because I sound like I ought to be there and all that. But it still doesn't mean that that I don't know that so-and-so is somebody's cousin and that person's married to his wife. And so that's, when you go to these places, be nice to everybody, every clerk, every person, open the door for people, do all the things that you can, because you never know when that'll pay off, or that your rudeness might hurt you in a way that you don't expect. At the last hearing, you could tell the judge was not interested in anything Boone has to say. And that's true, and he shouldn't be. Again, it's not her presence at that hearing when she has counsel is not for her to then just talk about anything she wants to talk about. It's to allow her to observe it. But of course, I think that's the one you're talking about, is the one where the judge, where she said, "But Judge, everybody didn't get to read my last letter, Judge." And so I think they put it up there. It's like going back to 1950. Yeah. Now, that's also, while it is true, of course, in some cases, in some of the counties we've got, it's also was interesting to me watching that, that OJ miniseries or whatever, where they had the Winston-Salem hearing and showed the courtroom there. And the one on the show did not look like the courtroom in Winston-Salem, which looked like a, pretty solid courtroom, Winston-Salem, having at least a few large courtrooms, and they scheduled that hearing in the big one. And I know I mentioned that a few times, but this case never seems to go away, that, Johnny Cochran came to town and did that. Now, I will say there that he was a guy who was very comfortable flying into North Carolina and going into a Winston-Salem courtroom and making an excellent argument, but he didn't win in front of that judge. He did not convince that judge. Fortunately for him, he got enough on the record that the Court of Appeals overruled Judge Wood, but, he had local counsel, and that person didn't do anything any more than our firm did for the other side as local counsel. You're just there as part of that process so the outside counsel can speak and handle the real case. But they made it look like it was, from the 1850s or something in that drama series, but it didn't look like that at all. I have family in Winston-Salem. Yeah, I practiced there for a while. Winston-Salem, cigarette territory there, people. Winston and Salem. And so, Legal Focus says there were no Asian people in that courthouse. If you're talking about Bladen County, then yeah, courthouse is full of downtrodden-looking black and white people. Well, see, that's why I can fit in, see, because that's me. So I might have been there and you wouldn't even have noticed it, but probably not so many Chinese people in court there. But, come to speak of it, there's a lot of Asian people, of course, around this area, but I don't know how often I ever see them in court. I'm not going to take that any further than that, other than to say that's a good thing, right? Even when I had to go to jury duty recently and was sitting in there all day just looking at people, I just saw what I saw. I was involved in a case a long time ago for civil forfeiture that involved Chinese restaurants, family owned, and the government seizing money from a supplier and wanting to keep the money, even though they had no basis to keep it. It made me not a fan of civil forfeiture and not really a fan of federal prosecuting authorities after seeing how they handled that. What else we got? I think that's about it, because we're down to talk about local stuff in North Carolina, old school court practice and stuff. Talk about how we never saw Asian defendants. Well, like I say, that's the interesting thing. Now that I think about it, of course, I never practiced criminal defense, so I wouldn't really know, other than being in the courtroom and looking at the people in the courtroom, who's doing what. But that they're not fully represented there, I don't think, as defendants. And while it probably is rising, I still don't think that population is significant from what I've seen, or even as people in litigation. It's interesting. You think they'd be in as many commercial fights as anybody else, but maybe not. Maybe that's cultural, and if it is, it can only be positive, because it's hard to win in civil litigation unless you're a plaintiff, getting money from somebody or something like that. But in terms of business disputes and stuff, the the process cost is so expensive for both sides to pay lawyers and things. It's hard to come out really on top. While you have to do it sometimes, it shouldn't be your first route is to litigate. But we do it sometimes. I litigated recently on something that we ended up settling it, and I conceded maybe more than I would have simply because the defense immediately accepted responsibility and were pretty good natured about the mistakes they made, and we worked it out pretty easily. So that was good. And that was good because that was the first case I filed with this new exciting electronic filing system that they have in Woke County. And I wondered how that would go, and it wasn't too bad, actually. Kind of missed having to go down to the courthouse to do it, but it was okay. Did it right here from this desktop. The whole thing, actually. I never had to go down there. The whole case from right here. That's crazy. All right. Sorry for blabbing so much. I am sick and a little better than yesterday, and so I'm probably not making too much sense. But we've gone through all the Sarah Boone stuff, I think, and I appreciate everybody stopping by. And if you notice, I used a new shorter intro. Some people have kindly remarked they'd like a shorter one, and some people who aren't regular viewers have just been rude about it. And those people I don't need to hear from, but I do want to respect what people are saying about that. You hardly ever go to the courthouse anymore. It cuts down on gas. Yeah, it's okay. You know, I wanted to hate it, of course, because I hate all change. But it was not as confusing to me as the federal system, I will have to say. And it actually worked all right. Okay. Some pretty good jokes there about Sarah Boone, and there are plenty about that, even though the case is unfortunate. Well, guys, I appreciate everybody coming by, and I think I've tried to say goodbye twice, and I still haven't managed to do it, but the third time is the charm, and I'll talk to you guys later. Thanks, bye.